Hello, my name is Henry Quillian. We're here at Taylor English Duma in Atlanta. I'm here with a lot of my colleagues in our litigation department who will soon be quiet. Stop talking. We are here to discuss the rules associated with 30B6 depositions, the depositions of organizations under the Georgia Civil Practice Act. Though a lot of what we will discuss will also apply to the Federal Rules of Civil Procedure 30B6 because really the vast majority of Georgia law and judges rely upon what is said regarding Rule 30B6 in federal court because the federal rules were amended and then the Georgia rules were assimilated to the federal rules. Here at Litigation Fundamentals with Henry Quillian, we are not sharing legal advice to those who may watch this video. We are discussing subject matters that you can go to your lawyer and talk about when you engage them for your litigation. And you might ask questions about what we talk about or make suggestions, but do rely on your lawyer and not on this video. And if you are litigating a case by yourself and you're not a lawyer, I highly recommend that you retain a lawyer. So the topic of 30B6 depositions relates to how a party in litigation can go about getting testimony from an entity which is other than a natural person, which could mean a partnership, a corporation, an LLC, a governmental authority, or an entity that legally exists separate and apart from a natural individual. The specific list in OCGA 911-30 small b 6 is a public or private corporation or a partnership or association or a governmental agency. So that is the group of entities that is a 30B6 is applicable to. Does anybody know what the last sentence in Rule 30B subsection 6 says? The last sentence. The last sentence says, this paragraph does not preclude taking a deposition by any other procedure authorized in this chapter. And so just keep that in mind when you're figuring out whether a 30B6 deposition is appropriate, whether you have other options that you might want to pursue in lieu of a 30B6 deposition, and whether you want to take depositions potentially of the exact same people who testified at a 30B6 deposition on behalf of a corporation, whether you want to take their individual testimony because their individual answers might be entirely different from whatever the corporation's answers were in the 30B6 deposition. That would seem to be illogical, but we'll go through why an individual might testify completely differently regarding the exact same subject matter as the corporation that they just testified on behalf of might testify. So the reason why I brought up this last sentence in the 30B6 paragraph is because there's historical practices that were utilized by lawyers before the Civil Practice Act, before the Federal Rules of Civil Procedure, by which a party might specifically designate a managing agent, an officer, or a director of a corporation or some other similar legal entity to testify on behalf of that corporation or legal entity, other than by using Rule 30B6, which is now in place. And that paragraph has been, that sentence in the paragraph has been interpreted to mean, hey, we didn't get rid of those procedures. We only added a new procedure. A procedure we'll go through in detail here in a bit. And there's a case in Georgia, Atlanta Associates versus Westminster Properties, 155 Georgia Appeals 204, 1980, which apparently affirms that a party can designate, an opposing party can designate a corporate agent for the opposing party to testify as the corporate representative for that opposing party, except that that party that's saying this person is the corporate agent has to actually establish that that person is an appropriate person to be testifying on behalf of the opposing corporate entity, which could be a burden that if the Court of Appeals, after you win based on that person's testimony, decides that that worst person was not an appropriate representative of the opposing corporate entity, that could be a very disappointing outcome. But just keep that in mind, that they've got this last sentence that says this does not preclude anything else under this chapter that's allowed. And of course, under the Civil Practice Act, you can, if you're a party, notice up the deposition of any person or from whom testimony could be obtained within the scope of discovery and cause them to come testify. So, with that said, what is Rule 30b-6? Why does it exist? And how can you use it in your litigation? So, we've already talked about the fact that it's for deposing corporations, let's say, as an example. Why do you have to have a special rule for corporations?
Because the corporation can't talk.
Corporation can't talk. And so you're trying to get testimony, right? So if you have a non-talkable entity, a non-fluent entity, then you have to have somebody representing that corporation to share the position of the corporation. And in many of our litigations, I would say in the vast majority of them, it's actually a company that is a party to the litigation, right? We sue a lot of individuals, but we also, lots of times, it's just corporations suing corporations. And is it possible that a corporation can have a different point of view from the people who work for the corporation?
Yes.
Yes. And why is that?
Corporate entities. What may be significant to the corporation may differ from what the individual's understanding is.
Okay, so what's important to the corporation may be different from what's important to the individual who participated in an event. The corporation, a person might testify regarding what they believed was in the contract between the corporation and the other party, but if the corporation says, well, that's not what the contract says at all, then the corporation might have the right to rely, or would have the right, generally speaking, to rely on the actual words of the contract as opposed to what the person thought the contract said, for instance. Or they may take some other position, the corporation might take some other position that's wholly different from, on a legal basis, from what the person who worked for the corporation might think. I mean, Chantel does, all this sexual harassment suits and things like that. I would think that the CEO who's allegedly sexually harassing somebody might take a different position regarding whether a sexual harassment took place than perhaps the corporation would take, or the HR person. So that would be an example about whether the corporation wants to take the official position that nothing happened because that's the CEO's version versus the corporation taking the position that, yes, something happened, but it wasn't sexual harassment or whatever the case may be there. So what does this rule allow, facilitate to happen in the course of litigation? So I'm just going to read a short paragraph ending in that special sentence so that we'll know what we're talking about. First of all, this is under Rule 91130, which relates to the general requirements for examination and taking a deposition. And it says in Rule 30b-6, deposition of an organization. A party may, in his or her notice, meaning the notice of deposition, name as the deponent a public, private, or private corporation or a partnership or association or governmental agency, and designate with reasonable particularity the matters on which examination is requested. The organization so named shall designate one or more officers, directors, or managing agents, note that's a limited group of people, or other persons who consent to testify on its behalf, or other persons who consent to testify on its behalf, and may set forth for each person designated the matters on which he or she will testify. The person so designated shall testify as to matters known or reasonably available to the organization. The paragraph does not preclude taking a deposition by any other procedure authorized in this chapter. Okay, so you can say, oh, that's real straightforward, except for it's not. Wouldn't you expect a deponent in litigation to actually have some personal knowledge of the subject matter regarding which they testify? Who thinks that's the normal course, that the witness who comes to testify, assuming they are testifying in litigation regarding a particular subject, who thinks it's this basic thought that they would actually know something about the case that's been wrong? Okay, that's that's what you generally would think. Is there any requirement under Rule 30b-6 that the person who's designated to represent at a deposition as a designated person in the 30b-6 deposition actually know anything about the lawsuit based on personal knowledge? No. So what does that mean? That means the corporation theoretically go out on the street when they get a 30b-6 deposition and engage a homeless person, train that person up, and have them come testify on behalf of the organization. So long as that homeless person what? Consents to testify on behalf of the organization. So that would be the extreme example. How often does that happen? That they hire the homeless person to come testify on their behalf. Rashmi says it's never happened. Well, let me show you this. Okay. But an example that might happen, on the other hand, potentially would be you hire maybe a seasoned person who does a lot of testifying to come in and does a lot of legal work to come in and testify on behalf of your corporation. Has anybody ever run across a response to a 30b-6 deposition where you wanted the organization to testify about 3 subject matters, let's say, where a lawyer has been hired by the corporation to come testify on behalf of the corporation? All right, I'm seeing all shaking of heads. That's never happened to me either, but that would be a potential situation where the lawyer consents to testify and then is designated by the corporation to testify. So I'm just trying to put into your mind the things that could happen so you won't be totally shocked by them if you show up at a deposition and you're not getting the persons that you think are going to be designated. So let's talk about this. So how would you start if you were a litigant and you wanted to find out what a corporation's position was on a particular subject matter within your case, assuming that, let's assume for the moment this is an opposing party, how would you go about pursuing getting that testimony? Well, I've already talked about the very first words is a party may in his or her notice, right? A notice of deposition. So you would start off with a notice of deposition. And you've got to designate as the party seeking the examination subject matters for the deposition. If you've got a commercial suit, can you designate as the subject matter of the deposition, let's say, anything related to the complaint in the lawsuit? On your notice of deposition, you'd say, you are hereby required, Mr. Defendant, to designate an officer, director, managing agent, or other person who consents to testify regarding the subject matter of the complaint or lawsuit. Can you do that?
Yes.
Okay, the answer is yes. Is it smart necessarily to take a position of just giving a really broad description of what you want the testimony to be?
No, you should be more specific.
Okay,
Depends on the case.
there's a,
In
how many
some-
people think it ought to be more specific?
I do, but I also think it
Some
depends on the case.
Okay, yeah, so it depends on the case. What if it's a one-issue case? What if the only issue is, did so-and-so send a notice of breach under a contract or a demand letter or something like that? If that's the only issue, then, and the complaint is so limited, then there would be any problem, I wouldn't think, designating that as a subject matter. Now, what about on the flip side? Can you say, we want to know, as part of the notice of deposition, we want you to designate an agent and tell us whether this person actually signed this document on behalf of the corporation. So this topic might be the persons who laid their hand on the signature line on the contract between companies A and B.
Yes.
Can you be that finite? Yes, you can be that finite. So that would be an issue, like let's say there's fraud or something involved and the company saying this is an unauthorized contract, or we didn't know anything about this contract, or there's some fraudulent party has put the name on it, it's not actually the signature. You could designate a very specific question and ask them, or, so you could have the opportunity to ask, is this really the CEO's signature or not? Okay, now, how many topics can you put, if you're the noticing party, down as your requested topics for a 30b6 deposition in a lawsuit pending in Georgia?
Depends on how much you want to fight with opposing counsel.
Okay, it depends on how much you want to fight with opposing counsel. And who's ultimately whose mind are you worried about affecting with respect to how many different topics you put down? If push comes to shove.
Judge.
The judge, okay. So would it be good to put 350 topics? No, because most judges, even if it's the most complex case in the world, most judges are going to look at a notice of deposition under 30b6 to a corporation with 350 topics. They're just going to say that's too many, right? Even if they are perfectly legitimate, even if it covers the exact 350 questions you intend to ask in the deposition, chances are the judge is going to say, because they probably apply rules of thumb, they're probably just going to say that's too much. Now, so we've gone from potentially one designated topic, basically everything that's occurred in relation to the lawsuit, everything that's in the complaint, all the way down to asking every question that might be asked in the 30b6 deposition. So what can you do? What would you consider to be a median number of topics for a complex commercial suit in a 30b6 deposition? Just throw out some numbers. 10 to 20, okay? So 20, 10, okay. I really think that's probably, in complex commercial litigation, that's probably pretty much the sweet spot. I mean, obviously it could be less, it could be slightly more, but 20 is not so much, I don't think, in a complex case to get a visceral reaction, especially if they're well crafted from the court to say this is way too many, there's no way I'm going to compel this deposition. And 10 would be, I would think, perfectly acceptable, wouldn't even be suspect in complex litigation. And it probably gives you, if you've crafted your topics well enough and constrained them well enough as to time and subject matter, that chances are, if you do it right, you're going to be able to get that corporation to testify regarding those topics. Now, what do you have to worry about when you're describing your topics? What is one delimiter that you might want to really think about before you just throw a topic down in the deposition notice? A universal delimiter that always exists, and something that could be limited that may not be because you drafted your topic poorly.
Period of time issue.
Period of time. Yes, so for instance, don't just put down, say it's an antitrust case and it's a 100-year-old company on the other side, don't put down every contract signed by this corporation. It's gotta be obviously focused, just like any other discovery would be, as to time, the period that would be relevant to the lawsuit involved. And similarly, it might be limited as to geographical constraints, subject matter topics. I mean, the subject matter, underlying subject matter of the matter at hand. So just like if you were asking an interrogatory, when you're putting down a topic, you need to be careful about whether this is going to be that's either so broad that the opposing lawyer fights on every single topic, or so narrow that you're going to end up with way too many topics, and some judge will say, or the opposing party in the first instance is going to say that's way too many topics. There's no way we can prepare somebody on that many topics. Did you have a comment or question? Thought I saw a hand go up. Okay. All right. So where would you actually put these topics? We've sort of talked about it.
Exhibit A.
Exhibit A, typically, it's an Exhibit A to a notice of deposition that expressly says that you are serving this notice designating the corporation as the deponent, not an individual. Make sure you have that clear in your notice. And typically, people use an Exhibit A that lists the topics of examination. Could be within the body of the notice. There's no problem with that. But if it's more than a certain number, you're going to end up with a notice that looks different from other notices, for lack of a better description, maybe longer. And that notice obviously has to be served in the same way you would serve a notice of deposition or any other notice of deposition. Now, if you're sending it to the opposing party, do you need to send a subpoena?
No.
Okay, no, because it's a notice of deposition. If they're a party, they're going to be compelled to come to the deposition, presumably you set it at the location that they can be compelled to come testify. Now, with respect to the amount of time in advance of a deposition that you would want to serve this notice of deposition, should it be as short as you might give the other side to have a clerk who's worked on one matter to come testify, or should it be many months, on the other hand, to give advance notice to the corporation?
Somewhere in between.
Somewhere in between. So basically you need to take into account the fact, hey, if this is super complex litigation and I'm sending this list of topics over to the other side and they have to do what? They have to determine who's going to be the people. It could be multiple people testifying regarding these multiple topics. And they have to prepare those people to testify, especially if the person is somebody that's just been consented to testify who knows nothing about the lawsuit, nothing about the subject matter to start with. Then that's going to take time, right? And what are you going to want them to be prepared to do when you actually show up at the table?
Testify.
You're going to want them to be able to testify about those topics with a reasonable degree of confidence, right? I mean, at least competence, not necessarily confidence. But if your goal is to get valuable information out of the 30B6 deposition and to do the deposition only once, then you're going to want those people to have the opportunity to testify. So let's flip it then. So if you're representing a corporation or an organization and the other side sends a 30B6 notice with a number of topics that require some study. What do you want to do pretty soon after getting that notice?
Talk to your client.
All right, talk to the client. You better get it to the client, right? And then what are you going to ask them or talk to them about?
Who's the testify? Should be, how long it's gonna take to prepare,
Yes.
gather information.
Okay, so who the witness be, how long it will take to prepare, where's the information that you're going to use to prepare, and okay, so when you're talking about who's going to testify, what factors would you take into account?
Do they already have personal knowledge? Are they good witnesses?
Okay, I'm repeating this because I've got this microphone. Do they have any personal knowledge already? So do they already have a head start on this subject matter? Would they be a good witness? And that is a huge thing because you can have the greatest, smartest person that actually has personal knowledge of the subject matter, and that person might be completely unintelligible as a witness or completely a bad representative on screen, let's say, often a video deposition for the corporation. Not because they don't know the subject matter, but because they just come over terribly. And you don't want them to be the shining star for the corporation. So, yes.
Also, if the topics are varied, whether or not it might be advisable to have more than one person be the corporate representative.
Yes, so if the topics are varied, let's say it's, on the one hand, it's engineering issue, and the other hand, on another topic on the exact same notice, it's an accounting issue. Does Rule 30b-6 allow an organization to designate more than one agent to testify in response to a 30b-6 deposition?
Yes.
Yes, it does, because it says shall designate one or more officers, directors, managing agents, or other persons who consent to testify. So, we had one last week where I think there were 8 people that testified in one 30b-6 deposition. But that gives rise to another topic. If you're the one planning the deposition, what should you do with the other side with respect to actually getting a good substantive deposition accomplished? If the normal rules for the taking a deposition in Georgia, including a 30b-6, are a total of 7 hours, what should you consider doing?
Have them identify in advance which witness is going to address which subtopic.
Okay, identify in advance which witnesses or which subtopic, because that will help you to do what?
Focus the questions.
Focus the question and prepare for the deposition in other ways by gathering documents, etc. What else might you consider talking to the opposing parties?
Sequencing.
Sequencing of the people who are coming to testify?
Yeah, of the deponents.
Okay, so you may clump subject matters that are similar together based on what witnesses are going to be offered by the other side. Anything else?
Have them all there and available.
Excuse me?
Have them all there and available.
Okay, have the witnesses there and available because that cuts down on what?
Delays.
Lost time, delays.
So I have a
Watch.
question. Is it possible to request the documents ahead of time from them?
Aha, can you request the documents ahead of time? Well, I don't know. Can you request documents from an opposing party?
Yes.
Okay. And so how far in advance, at a minimum, do you need to do that?
30 days.
At a minimum, that's if you hand serve a request under 9/11/34. But how much prep can you do if you get the documents on the day of the deposition? Not much. So the normal course would be, you just did the generic litigation, is you would serve a request for production of documents, you would get those documents, study those documents, determine which subject matters are relevant, then send out a 30b-6 notice seeking the deposition of the corporation regarding the subject matters that you've determined, having done all your analysis, are important to the litigation. One goal might be, what if you're, let's say, the plaintiff, and you're trying to get evidence within the course of litigation, what might your ultimate goal be with respect to getting that deposition testimony? looking at the litigation as a whole.
Settlement?
It could be settlement, yes. In other words, take a great deposition, make the people think you know what you're doing and settle it. If the company is the opposing party, they're gonna be able to do what at trial? They're gonna be able to appear at trial, right? So you're not as worried about trial except for purposes of cross-examination and impeachment that we go into. But also, what do a lot of corporations do in the course of litigation when they're a defendant in a lawsuit? After discovery closes,
Motion for summary.
they move for summary judgment. So, yeah, you might need to think about designating topics that you need to nail down and try to get testimony from which a question of genuine issue of material fact can be raised so that they can be defeated, their summary judgment motion can be defeated. Yeah.
So in the example you gave where you said, say there are issues that an accountant would answer and one that an engineer would answer.
Mhm.
Say the company only designates one or the other, but you, as the plaintiff, the noticing party, really wanted both. Would
Yeah.
would you have to notice that other person individually, or?
Okay, I'm going to repeat the question. I think I've got it, Zach. So let's say that you put down a notice deposition that has two completely disparate subject matters, one being accounting, one being engineering, and it's, as we've looked at in the rule, which party actually designates the representative of the company? The recipient of the notice, the opposing party, right? What if they only show up with one witness? If the accountant comes in to testify regarding all the centrifugal force issues involved in the machine that's at issue.
Well, you ask him, do you have personal knowledge of these engineering issues? And presumably they'll say no. And then you say, well, with whom did you talk in preparation for this deposition to educate yourself about these issues? Then they'll presumably give you a name, and yes, you do that.
Okay.
Take the deposition of that individual.
So Mr. Jones has shared, yes, you walk down an entire path, one with the witness that has been presented, find out how well they did to prepare to be ready to testify on the topic, because you're sitting there going, well, you've got a green visor on, you don't have a pocket protector and a slide rule. So how in the world did you learn about this centrifugal force issue in this machine? And then you ask, who did you learn that from? What documents did you review? And you can do subsequent follow-up depositions with the individuals who, from whom they learned. That goes directly to that topic of the use of 30B6 does not preclude any other depositions that might be taken. And that would only be true, by the way, just remember it might count as a deposition if you've got a scheduling order or some other agreement regarding a limited number of depositions that can be taken. So what happens if that accountant is really like the incredible doofus and doesn't know anything about the engineering issues? As we got that topic on the table.
Then you object and you insist that they produce someone with knowledge.
Okay, so at the deposition, you would need to say, this person has been, we have all these topics on the table. It's the duty of the corporation to designate somebody who is prepared to testify and to share the corporation's position on this subject matter. The corporation has completely failed to present a witness who can testify on this subject matter, and that is sanctionable conduct under OCGA 91137A2. One of the subject matters, that's the general discovery, motion to compel, motion for protective order, and sanctions statute. OCGA 91137A2 says, if a deponent fails to answer a question propounded or submitted under 91130, which this would be, or 91131, or a corporation or entity fails to make a designation under paragraph 6 of subsection B of Code Section 91130, or blah, 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 or a party fails to answer an interrogatory, blah, 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 or a party, the discovering party may move for an order compelling an answer or designation or other compelling inspection in accordance with the request. So if the corporation fails to present prepared witnesses for the subject matter that has been designated in the notice of deposition, then you have a 91137A2 motion you can file to straighten that out. What do you have to do before you file that motion?
You concur.
You have to make a good faith conference or good faith effort to reserve the subject matter of the dispute regarding discovery. And does that mean that you just write a letter saying you did not send somebody who was prepared to testify?
Do a little more than that.
Okay, you have to do a little more than just send a letter. And by the way, I think most judges will say just sending a letter saying you did your discovery wrong does not constitute a good faith conference as required by the Uniform Superior Court rules prior to filing a motion to compel or a motion for protective order. A lot of people do that and they call it a Rule 6.4 letter, but that's just supposed to start the conversation. It's not supposed to be the conversation. So you've got to have your good faith conference, but a corporation who fails to do that can get sanctioned for failing to designate a representative who is prepared to testify. What kind of sanctions could apply? Just in general, we won't go into that in detail.
Attorney's fees.
Attorney's fees. It can go all the way down the line, and those are actually expressly denominated under 91137B2, and it could include striking of the pleadings, whether it be the answer or the complaint. If a corporate or organization party does not comply with Rule 30b-6 deposition, and they're shown to basically be doing it willingly and purposefully and maliciously, then the court may say, okay, well, you have no answer. You don't have to worry about, well, this person testifies regarding liability anymore. Yes.
Question, so if it's the plaintiff who's, obviously they're the ones who do the complaint, and the defendants are the ones who send the notice, 30b-6 notice, and they don't get the correct, witness that based on the topic, is it possible that some of the things that are, some of the counts that are in the complaint can get knocked out because they're asking you know what I'm saying?
Yes, okay, so basically I think this raises the question of, all right, so and it's a point that needs to be made, a major goal of a 30b-6 deposition is to get the official corporate position of the party, or it could be a third party, by the way, we have not mentioned that, which would require a subpoena, the official corporate position of that entity. And if it is a party, that means that what can happen, what sort of evidence can arise in a 30b-6 deposition of an opposing party that'd be easily gotten into evidence in your favor?
Admission.
An admission, okay. So, Rashmi has asked, so what happens if the opposing party puts up a witness that gives the defendant, in this instance, really good testimony for the defendant? Let's say they make an admission that would eliminate one of their claims. What can you do with that admission?
Summary judgment.
You can move for summary judgment. And if the person, let's say you get the person off the street to come testify on behalf of your corporation. People that came in late have no idea what I'm talking about. And that person secretly does not like the corporation that they're testifying for. And nevertheless, they're put on the stand to be that corporate representative, and all sorts of admissions are made. What's the result of that for the opposing party? dancing in the street, right? It's dancing in the street. However, that doesn't since we're sort of on that topic, dancing in the street doesn't always apply, as was discovered in a recent Georgia case, Robles, R-O-B-L-E-S versus Yugueros, Y-U-G-U-E-R-O-S, which is 343 Georgia Appeals 377, 807 Southeastern 2nd, 110. It's a 2017 Court of Appeals case. In that instance, there was a medical malpractice case. The lawsuit was against a doctor and against the employing entity doctor, the entity that employed the doctor, which in turn worked at a hospital. And the plaintiff did a 30B6 notice on the opposing entity, the medical group. And one of the topics was the care of the patient during the time they were in the emergency room where the patient was treated by the doctor who allegedly committed malpractice. The 30B6 deposition respondent, the corporate entity, the medical practice, designated a doctor who practiced in the exact same subject matter area as the doctor that allegedly committed malpractice, and that person appeared on behalf of the entity. The doctor who appeared on behalf of the entity admitted that the doctor who was caring for the patient had acted below the standard of care in the 30B6 deposition. So, what does the plaintiff's attorney probably do at that point in the deposition?
Fire their attorney.
No, what does the plaintiff's attorney
Oh,
do?
okay.
What does the plaintiff's attorney do?
Stop the deposition.
Stop the deposition and file a motion for summary judgment or something within 24 hours, right? And dance in the street in the meantime. Well, that's what they did. They took the position that the corporation had just admitted that their doctor had breached the standard of care. It was a death case, by the way, that the death had occurred because of that breach of the standard of care, and that the plaintiffs had the right to recover against the corporation, which undoubtedly was insured. The trial court, however, excluded the testimony of the 30B6 witness. And why did throw out some ideas? Why would the trial court do that? Silence.
Was the doctor, I don't know, was he not qualified to give that opinion?
The doctor was not qualified as an expert witness. There was no underlying, other than the fact that the person was a doctor, there was no designation by the opposing party that the doctor was an expert witness for that party. There was no foundation laid that that doctor was qualified in the specific procedure at hand. And it went on, basically the Court of Appeals, so the trial court ruled to exclude the evidence. I believe that was a trial. The Court of Appeals reversed, said the evidence ought to be admitted as admission in judicio against the medical entity. Got cert to the Supreme Court. The Supreme Court ruled that under the new evidence rules, OCGA 911-24-7, 702B, which is essentially Georgia's version of Daubert, that the baseline introduction of evidence regarding the presentation of expert witness testimony had not been established, and that the party who testified on behalf of the corporation, even though it was an opposing party, was not laid, and so therefore the evidence was properly excluded by the trial court. And then it got sent back down to the Court of Appeals, which of course then affirmed the trial court's decision based on the Supreme Court's determination. So what does that tell you? That tells you that 30B6 depositions potentially are not as valuable as you might think they were, because you might not get an admission, even if it's said in a deposition, that actually sticks, because the other evidence rules are not supplanted by the procedural rule. It tells you that, and there is a distinction here, is there's judicial admissions that are made in pleadings, like an answer, which generally is an admission for all purposes. Well, it may be admission for factual purposes. And then you have judicial admissions or admissions in judicio that are a result of requests for admissions, which are completely binding and sort of all-encompassing. And then you have deposition admissions, which are only, which are then sifted by the rules of evidence as to whether they can get into evidence or not. So I found that to be a really interesting case that had recently come out. So if you're in a deposition and you're deposing somebody and you think they've made a great admission, you need to be thinking, does the testimony they just gave satisfy all the evidential requirements for getting into evidence, or is it merely an admission of a party opponent making it admissible?
Hey, Henry, is there any restriction against a corporation designating multiple representatives for every topic?
All right, so the question is there any prohibition against a corporation designating multiple individuals for a particular topic, or for every topic, right? And the answer is, I don't believe so. I don't think there's a prohibition of it, because the rule just says one or more witnesses. The only thing that I would think would be prohibited is if the outcome was that designee 1 on one topic says yes and designee 2 says no, because then you're going to end up with a non-official position. So it sort of depends on how broad the topic is. Yes.
Well, I've had this situation arise, and two things happen. One is they run you through the gamut with the first witness, so then you know what they're going to ask the second and third on that topic, because the first one plays Mickey the Dunce and says you'll have to ask me before I can answer. And then the second is exactly what you just said. They correct something that's said incorrectly. And even if you don't ask the question, because you're smart, you're not going to ask the question again. They just work the answer in. They're coached to work the answer in, regardless of whether it is responsive to the question.
Okay, so you have a situation where, let's say the topic was the light green or red. Witness number 1, you have to go through and ask, do you know about this? Do you know about this? What about that? And so they know everything you're going to ask. And then witness number 1 says, I don't know whether the light was green or red. I was looking there on the way. That's the corporation talking, right? Maybe it's on their premises. But then the next guy never gets asked the question, and he just yells out, but the light was red, something like that. So they get it onto the transcript one way or another. Now, what can you do if you're the asking party in that 30B6 deposition? What can you do to get the light was red out of the record?
Object, the answer is not responsive.
Yeah, you can ask that. You can say the answer was not responsive to the question. And so that the judge might strike that, but the chances are slim. But
Yeah, their
you can
counsel's
try.
just going to ask the same question, before the depo's over, so it doesn't get it out. I mean,
Oh, I see. Yeah. Well, so the opposing party might come forward, but they would have to ask it in a non-leading fashion, right? If they want to ultimately enter it into evidence, presumably. But it still might be enough to defeat summary judgment. So before you show up at the deposition, other than getting prepared for the deposition itself and anticipating whatever might happen to the deposition, what should you have in your hip pocket or your purse? The number for the court. Why? Because disputes come up in depositions, right? And if a dispute comes up concerning whether a party has designated the appropriate people for a 30B6 deposition, you can potentially suspend. You can certainly make note of that and then say come back later or after a motion to the court if the other side doesn't concede after a good faith conference. But if they do what they did in this other case, designate 10 people on every subject matter, then you can call up the court and seek a ruling from the court. You know, what do I do in this circumstance? I asked a single narrow topic, and they've shown up with 3 people on the same topic. They want me to ask the same question to every witness. And 2 of them say, I don't know, and the third one is then therefore prepared for the answer. Never had that happen, but what does that lead to? I asked Craig Pendergrass the other day. He was unable to come today. He said, oh, this is on 30B6. I would love to come to that. Sorry, I can't. I said, well, how many topics would you normally list? He goes, it depends on how much you want to argue with the other side. And that's the exact same thing that Sean tells us, that every topic could be a subject matter for contention in a 30B6 deposition. Either they just decide, the other side just decides there are several topics we're just not going to talk about in this deposition, so nobody's going to show up for it. If it's only 1 out of 10, they'll probably never follow up again and get a deposition on that last topic. That would be one possibility. Another one would be you're going down the list of questions, and you got the witness on a roll, and you're getting all sorts of great information regarding the subject matter, and then what objection do you get from the other side?
Beyond the scope of the.
It's beyond the scope of the topics. They say you've got a semicolon after this word, and that means it's a more limited subject matter than you think it is, and we're not going to allow this witness to testify regarding that subject matter. And you're just being abusive to this witness. Whatever the hemming and hawing that might take place in the deposition. What would be a solution to that? You've got the witness there. The witness obviously has personal knowledge regarding the specific subject matter. The witness works for the corporation. We're all sitting in the same room together. We've got 10 more depositions that has to be taken, and you only want one more answer out of this person who has been designated as a witness. What would be a solution?
Let him testify in his personal knowledge, not for the corporation.
Okay, so yes, you could enter into a stipulation with the other lawyer that for the purposes of this question, this person is only answering on their personal knowledge, not on behalf of the corporation. So therefore, it would not be binding on the corporation if the person says something that the corporation says is not its position. What's the probability of that working mid-deposition? I would say probably around 50-50.
Yeah.
It depends on whether you have frankly, I think it depends on whether you have a confident, competent, seasoned opposing attorney, or whether you have a super scared, brand new associate on the other side, who's sort of deer in the headlights. And there also might be another way you can work it out and say, well, let's defer that question to the end of the deposition if this person is going to continue to be the witness. And then let me ask the question, so it'll be a completely different transcript, so to speak. Maybe I've heard judges say they don't take too kindly if people are so stringent about the specific words in the topic that somebody obviously could just resolve the issue right then and there if they make the party come all the way back around and take another individual deposition of that person to ask one question. However, what would that tell you if you're the deposing lawyer and they really, really, really don't want you to ask that particular individual what his individual knowledge is regarding the subject matter?
Really, really, really want to ask that
question. Yeah. So you might think, okay, I just want to ask it now, but let me make a little note here and to send out a notice of deposition as soon as I get back to the office for the individual's deposition. Okay. So we talked about opposing parties. I'll go briefly into an it's gonna be very similar. What if you wanna take the, get the corporate position of a non-party to the litigation? Can you send a 30B6 notice to a non-party? Is it a notice or is it something else? Okay, you send a subpoena to a non-party for a 30B6 deposition, the notice of which goes to who? The opposing party, right? So notices are to opposing parties, subpoenas are to non-parties. Can you ask for documents?
Yes.
Yes, in fact, very, very frequently, parties will subpoena non-parties saying, and the corporation saying, produce all your documents on this subject matter for authentication for our use in this litigation. And so that's one of the ways you get non-party documents for Georgia litigation. What's the other way that you get non-party documents for Georgia litigation?
Non-party request.
Okay, non-party requests under what rule?
34.
91134. And there's actually a specific rule, I don't know if I can put my, 911B5. The notice to a party deponent may be accompanied by a request made in compliance with 91134 for production of documents and tangible things at the taking of the deposition. The procedure of 91134 shall apply to the request. That's that one. Somewhere else it talks about 91145 being used as a subpoena to obtain evidence from the opposing party. But quick practice point, can you just send a subpoena for documents in Georgia to a non-party to get documents without noticing a deposition?
It's not a subpoena, you just send a request.
You can just send a 91134 request. Can you just send a subpoena that looks like it's for a deposition to a non-party without actually noticing a deposition in Georgia?
I thought you were asking about documents, sorry.
Can you do it in lieu of showing up for the deposition, you just produce documents?
That's what I'm asking.
Yeah, that's what we do
Yes.
all the time.
You can do that.
Actually, you can do it under the, you need to actually have a deposition if you're going to subpoena the opposing party for documents.
Okay, you have to.
I believe there's an ethical rule on that. That is a violation, that if you send 91134 request, the opposing party has the opportunity to object and all this, they get a copy of it. But if you just send a subpoena, you're supposed to actually have a deposition. Now, you can work it out with the other side or whatever, but I believe that's the rule. You can't just send the subpoena. And then if the third part, non-party does not designate witnesses appropriately, who come prepared to testify on the subject matters stated, what are your remedies?
Move for sanctions.
Move for sanctions, same remedies you would have under 91137, except for it just wouldn't apply to opposing parties, so they can't strike the pleadings. Might be attorney's fees. Okay, I think that wraps up most of the subject matters and certainly our time under 91130B6. Is there anything final for the good of the order that anybody can share? Well, thanks for your very, very active participation. Even ideas came up that I'd never thought of before. And this is, come back next month for Litigation Fundamentals with Henry Quillian.